Hey, it's Mary Amick with EDU 503 on our Chapter 8 case study. This week, I looked at case study 8.5, Jackson versus the Birmingham Board of Education. This was a rather lengthy case, but very interesting in the way that the case kind of unwound and all the different cases that it actually ended up bringing in about gender equality as I continued reading through. It's about the plaintiff is Roderick Jackson, who is a teacher at Birmingham, Alabama, public schools. He filed suit against the Birmingham Board of Education, alleging that the board retaliated against him because he had complained about sexual discrimination in the high school athletics program. So Mr. Jackson was also the girls' basketball coach. He claimed that the board's retaliation violated the Title IX of Education Amendments of 1972. Initially, this court case was dismissed on the grounds that Title IX does not prohibit retaliation, and the Court of Appeals for the 11th Circuit affirmed that. As I continued reading about this, it talks about that Mr. Jackson was an employer of the Birmingham School District for over 10 years. 1993, he was hired to serve as a physical education teacher and girls basketball coach. He got transferred to Ensley High School in August of 99, and that's where he discovered that the girls basketball team was receiving unequal treatment as opposed to their male counterparts with funding and access to athletic equipment and facilities. The lack of this funding, equipment, and facilities use made Mr. Jackson's job as the girls' basketball head coach very hard. So in 2000, Mr. Jackson began complaining to his supervisors about the unequal treatment of the girls' basketball teams, but to no avail. His complaints went unanswered. The school failed to remedy the situation, and instead, Mr. Jackson began to receive negative reviews and evaluation, ultimately, which led to him being removed as the girls' basketball's head coach in May of 2001. He was still employed as a physical education teacher. He was just no longer allowed to coach the girls' basketball team. That's when he decided to file his case with the courts, alleging that he received retaliation based on the grounds of Title IX infractions on the Birmingham Department of Education. Now, as this court case goes through, is a lot of different cases it brings in. It talks about how the district court granted the motion to dismiss. The case was actually in the process of being dismissed, but we bring in here the Alexander versus Sandoval case, where the Court of Appeals concluded that the Department of Education regulation express prohibiting retaliation does not create a private cause of action for retaliation. And it's argued in here a lot that the wording of the Title IX piece of legislature does not actually explicitly say whether retaliation based off of those allegations with monetary and funding for those students, since Mr. Jackson was not the one being filed. I guess I'm not really sure if I'm saying this correctly, but what I gathered is because it was not Mr. Jackson who was actually the students that were hurt by this lack of Title IX funding, he was essentially the whistleblower. So it kind of goes to the same effect as if a teacher sees a principal or another teacher sexually harassing a student and the teacher's the whistleblower. Technically, the school board can dismiss them. They're not protected under any rights because the person who was sexually harassed was not the one filing the complaint. So in this case, Mr. Jackson was advocating on the rights of his team, but because Title IX does not explicitly have a policy that covers that retaliation, he was not granted that retaliation defense, if that makes any sense. So the case continues, and it goes back and forth. And again, like I said, they bring in the Cannon versus the University of Chicago, which held that the Title IX implied a private right of action to enforce its prohibition of intentional sex discrimination it also brings in many more cases in here about the about Franklin versus Gwinnett County Schools, and how private parties were seeking monetary damages for intentional violations of Title IX. Very similar cases to what he was trying to pursue, but the wording within that Title IX legislature just does not lend itself, I think, is really probably maybe the best way to say it, does not lend itself to actually proving a reason that you could prove that the board directly retaliated against him because he was trying to shed light, maybe a negative light on the program. Or maybe just they were able to take that away from him, the coaching side, so that they could kind of, in a sense, sweep it under the rug, which we all know happens a lot. So, in the end, and this is about a 5-page, 6-page case study, in the end, it says, to prevail on the merits, Jackson will have to prove, so he's going to actually have to prove that the board retaliated against him because he complained of sexual discrimination. The amended complaint alleges that the board retaliated against Jackson for complaining to his supervisor, Miss Evelyn Ball, about sex discrimination at Inley High School. At this stage of the proceedings, the issue is not whether the plaintiff will ultimately prevail, but whether the support of the claims, the evidence offers support to his claims. Accordingly, the judgment of the Court of Appeals for the 11th Circuit is reversed, and the case is remanded for further proceedings consistent with its opinion. And it says it is so ordered. So he actually did, through all the craziness and the originally being dismissed, thrown out because it wasn't accurate, he did end up, I think, getting to the point where if he could prove that he was let go as the coach, then he could actually have a leg to stand on here and a case to stand on with these individuals. So, interestingly enough, I'm not sure how this ended, but I do think I will look it up to see if I can figure that out, because I think there's a lot of instances where things like this happen in the world. And I mean, Title IX is a huge thing. Gender equality is huge right now, and it's something that I think we all could do further studies on and be more well-versed in as we move forward. All right, sorry I look so rough here. I've been at the beach. It's spring break for me right now. Woohoo! So I hope you enjoy that case, and thank you for watching.